Welcome back. You're watching The Firm. Whoever coined the phrase Incredible India would have hardly expected it to extend to tax policy. But it does. Incredible India is the best way to describe the Vodafone saga, in which, after a many-year court battle, a foreign investor wins a multi-billion-dollar tax case in India's Supreme Court, only to lose to a retroactive amendment of the tax law, and then discover that the unfortunate reversal of its fortunes may now be followed by a kiss and make-up session with the government. Well, technically it's called a conciliation, and this week the Government of India, armed with a brand new law minister, decided to proceed and conciliate the Vodafone tax matter. What in heavens does that mean? And what will the elements of this conciliation be? Well, to talk about that, I have with me Supreme Court Senior Counsel Arvind Datar, lawyer and tax expert Rohan Shah of ELP, and veteran tax consultant Ketan Dalal of PwC. Gentlemen, to all three of you, a very warm welcome. Rohan, let me start with you. What is this conciliation process going to be? Its elements, its design, and ultimately its outcome?
So, Menka, I think it's just conciliation loosely called. It's not a classical statutory conciliation, but I think its elements will effectively be whether the Government of India and Vodafone can agree to a path in terms of how they should resolve this controversy, which at the minimum has three elements: the tax that is supposed to be due, the interest, and the penalty. And one approach could be which is for the Government of India to turn around and say, well, no retrospective amendments, in terms of which none of these three elements would be payable, but I don't think that's on the table. What seems to be on the table is, would Vodafone consider paying all or some of the tax, and in lieu of that, can the Government of India take away the interest and penalty burden?
Mr. Dalal, I understand that the penalty can be waived given previous Supreme Court decisions regarding retroactive amendments. Some lawyers tell me there are provisions within the existing Income Tax Act to even waive all or part of the interest. So if that can already be done without a conciliation process, then what is this conciliation going to amount to if it doesn't amount to a reduction in the principal amount?
You're absolutely right, Menka, and as Rohan said, we're talking of three elements: tax, interest, and penalty. And honestly, for the life of me, I cannot see that the penalty, even in normal circumstances, could have stuck.
Well, what about interest? Do they need
Right.
a circular or a change in law to waive the interest, either all or part of it?
Yeah, okay. So, to my mind, there is a provision under Section 119 of the Income Tax Act, under which the Central Board of Direct Taxes can issue an order for an assessee or a class of assessees, and indeed they have done that in the past in the context of certain amendments which were made in Section 80 HSC, which dealt with some export profits. So this means that if at all there is a conciliation, and as Rohan said, it is could be loosely worded as such, the conciliation could only be for the principal amount.
Mr. Datar, if the heart of this conciliation has to do with renegotiating the principal amount, then that would need an amendment to the income tax law. If I understood this correctly?
No, not really. But before I answer that question, I just want to supplement the point of penalty and interest. As far as penalty is concerned, I agree with Dalal. There is absolutely no question of any penalty being levied. There are Supreme Court judgments to that effect. And as far as interest is concerned, there is a specific notification issued in May 1996 saying that if there is a retrospective amendment, then interest can be waived. Now, coming to your question on this method of coming to a settlement without the Income Tax Act, there is one area in which you can settle the matter without the Income Tax Act. In fact, your program talks of kiss and make up. I think there's an honorable way of kissing and making up and two dishonorable ways of kissing and making up. The honorable way is to accept the judgment and say that the law will be prospective. That's one part. Now, the two dishonorable ways of kissing and making up will be this. Vodafone, to my knowledge, has invoked the bilateral investment treaty. There, the Union of India is a respondent. Now, they can come to an agreement, theoretically, that let's say 5,000 crores will be paid by Vodafone as a settlement and in full and final settlement. So, there will be an award on consent terms whereby Vodafone pays only 5,000 crores as against its liability of, let's say, 10,000 crores. Now, that award will be binding on the Government of India without amending the Income Tax Act. That's one way of doing it. The other way which they are now trying is they are trying to come to some kind of non-binding conciliation which will be placed before Cabinet and then before Parliament. I do not know how it is going to pan out. under which provision of law they are going to do this, and it is going to lead to more and more complications.
All right, in the second case, for a
Yes.
moment, if I was to leave the investment treaty aside, sir, in the second case,
Yes.
any negotiation on the principal amount would in a sense be violative, if I can use that word loosely, of
Yes.
the retroactive amendment itself. So there would have to be an amendment to that retroactive amendment or section 9, and hence an amendment to the law to allow for a reduction in the principal amount. Have I understood that?
One way is to amend the retrospective amendment. The other possibility is to introduce a new chapter in the Income Tax Act permitting the government to come to such kind of settlements. At present, this issue can't be settled through the settlement commission, so you may have to have a law which permits such kind of settlements in future, because remember, if you make a law only for Vodafone, then again you are risking violating Article 14. It has to apply to all similarly placed assessees. So if it's a law only for Vodafone, then it makes it that much more vulnerable. So to answer your question, yes, if there is the non-binding settlement is then approved by cabinet and then it goes to parliament, then I think you'll have to necessarily amend the Income Tax Act to reduce the liability.
And if this is done under the aegis of the Investment Protection Treaty, sir, what kind of precedent does this set for other tax disputes that may arise out of retroactive amendments? Because let's not forget, we've had 24 of them last year, and that, assessees may seek to settle under treaties. Would they also then need to be extended a similar conciliatory framework?
No, if it's a consent term, then, for example, apart from Vodafone, let us say X Limited is agreed by a retrospective amendment, and it's a foreign investor which is residing in a country where there's a bilateral investment treaty. Then if it invokes the treaty, now Vodafone has invoked it on the grounds of unfair treatment and expropriation. So if a similarly placed company invokes its investment treaty, once again the Union of India has to either contest the arbitration proceedings or come to a settlement and have an award by consent terms. Now if they settle it for Vodafone, it's not necessarily they have to settle for others also, but then they'll find it difficult to say no to other companies which may also invoke such bilateral investment treaties. But the important point is, if you go the investment treaty route and it's an award on consent, then you may not have to amend the Income Tax Act, because that's a consent, it's an award binding on the Union of India.
All right, Rohan, do you think this is going to go through the treaty route, or do you think this is going to result in an amendment of the Income Tax Act?
So, Menka, two or three things. Firstly, I don't know if this is about reducing the amount of tax. I think, while legally we are all agreed that there should be no penalty, while legally we are saying it would be wrong for there to be an interest, I don't think that is a done deal. I think today these amounts still remain as outstanding against Vodafone, and I am not so sure that this is going to be about reducing the main tax demand itself. And as to how they can go about this whole issue of interest and penalty, they've used every route possible. So they've used circulars for the DEPB and DFRC, and the circular has secured a waiver of both interest and penalty. Recently in service tax, in retrospective amendments, they've used the legislative route to waive the penalties.
All right.
So I don't know
let
if
me
this
interrupt
is
you there,
really
Rohan.
about the base amount.
If they can waive tax, if they can waive the interest and penalty through various different routes as you've just described, then what is this conciliation about if not the principal amount?
No, the situation here is, this conciliation, why does it need to go to Parliament? I think that is what is engaging people.
Right.
Now, if the situation is that you have to work with the basic tax demand, then do you need an amendment, or do you need an amendment to section 9, or do you need an amendment in the form of empowering the government to settle? Now, if their situation is that they are trying to do something only specific to Vodafone, then the situation is they will want the empowerment route, and somewhere to distinguish themselves, in this case from others, the settlement or the conciliation will record the background of a Supreme Court order.
Can they, Rohan, can they even do that? Can they do something only for Vodafone? Would that be fair? What about the other companies impacted, not just by the retroactive amendment to section 9, but all the other amendments that took place last year?
Yeah. So Menka, break it up into the three parts again, which is tax, interest, penalty. If they make an amendment in the context of saying no interest and penalty, everyone similarly situated to Vodafone would get the same benefit, and it meets the section 14 and section 19 etc. tests. If you go into a situation of saying, I now want to impact the tax amount itself, then in that particular situation, it goes to a very case-by-case approach. Now, what do they need if they want to effectively impact the tax amount? Then they need a right to negotiate and to settle. And that will happen in the background of Vodafone's case. And one of the key facts in background is that they have a Supreme Court order. So the situation is, if they do something to Section 9, it applies across the board. If they take a right to settle on a case-by-case basis, then what you can formulate in each case is different, and to that extent what they may formulate in Vodafone, given all of the facts in background, may be very different and does not automatically apply to everyone impacted by a retrospective amendment.
And I just want to address one prior issue, which is I can't see any provision that can be made in the Income Tax Act to say the government can reduce a particular amount, because that could open another set of issues, not only for these kind of cases but generally. So I think either under a stretch of the Conciliation Act or under the BIPA is the only way that at least I see that a settlement amount can be arrived at insofar as the principal amount is concerned.
If you go by the bilateral treaty, then there's no need to amend the law. But if you're going to go by this non-conciliation route, you'll have to necessarily amend the Income Tax Act and put a mechanism in place, because you can't just make a law only for Vodafone. Now, how it is going to pan out is, you will have to take all those cases, not only in the Vodafone, not only in the 2012 amendments, but in future if there are any retrospective amendments, and they give rise to tax liability with penalty and interest backwards, then there must be a mechanism where a party can go and say, look, I'm willing to pay 60-70% of the tax amount on condition of waiver of penalty and interest. But then there'll have to be a set of rules and regulations to do that, because if you have a settlement only for Vodafone, I'm also expecting a large number of PILs to crop up saying that you can't do this and so on and so forth.
My sense is they've got two approaches. Either they look at the investment treaty route, which allows them to tailor something specific to someone covered by the treaty, or they have to bring in either amendment or circular which secures three things: a clear waiver of penalty, a clear waiver of interest, and if they desire to limit the tax demand, one approach is to say that their demand can only go back X number of years, in which situation they are able to, in some form or manner, restrict the quantum of the tax which could be collected. But doing something too complex runs the risk of your getting caught up either in a parliamentary debate or in a new stream of litigation on the ground of discrimination. So they will have to keep it simple. But if it has to appeal to the international community, which is what they want, then interest and penalty must go for sure.
Well, why do you need an amendment to the law for that? You can just do that through a circular. You don't need parliamentary approval, right?
You could, but even if you look in the past, they have adopted either the circular route under 119 or they have adopted a legislative route.
I do want to make one point on what Rohan said, which is, he said restricting the number of years. I don't think that can fly really, because what has happened is that, as you mentioned, there are 28 retrospective amendments in the Finance Act 2012 itself. So anything to try and do it specifically to address this kind of issue may have larger ramifications.
One formula could be to put an end to this kind of thing, is that in case there's a retrospective amendment, they can have a rule that if you're willing to pay the tax demand within, say, 3 months or 6 months, then the government can waive 50% of the liability. There could be some kind of rough and ready formula to avoid further litigation.
And some variation of that is already in the voluntary disclosure type of scheme that they have in service tax.
Yes.
They dictate time frames and then they give you some facilitation.
Why just 50? Why not 75 or 82
Anything. I mean, you could work on No, I know. There is no...
This, Mr. Datar, amounts to a discount sale at the CBDT, but this is unprecedented. So I suppose we might have to find an unprecedented solution for this as well. Gentlemen, I know this could go on for longer, but we're entirely out of time. Thank you so much for joining us, and thank you very much for watching. We'll be back with The Firm next week.